हाँ ठीक है सर, ठीक है सर। Hello. How about you?
Hello? Good afternoon, everyone. Thank you for attending today's session. We will be beginning in 5 minutes. Sandesh sir is already online. Uh, as the as soon as 4 p.m. As soon as we reach 4 p.m., we will begin the session. Please wait for 5 more minutes. Thank you. Good afternoon, everyone. I'd like to invite Sandesh Agarwal sir to take over the session for today. We'll be speaking on patents in particular today. Today's topic is patents. Sandesh sir, you may carry forward. I'm muting myself.
Uh, okay, thanks,
Ah,
Param.
yes, sir. Ah.
Just one thing, am I audible today better than the yesterday, or is it still requiring some sort of modification?
No, no, sir.
Good.
Today it is audible, sir. But please increase your volume while speaking.
Okay,
Ah, okay, sir.
thanks. I'm sharing my screen with you.
अरे, अभी तो हुआ।
This screen is visible to you?
Yes, yes sir. Sandesh ji, good morning. Welcome all.
Good morning, sir.
Nah, good. Sir, please observe it, sir. Some people are raised their hands.
Okay. I'm
Some
continuing.
people, Ram Babu, Ashish Musari, Sandhya
Yes.
Dake.
Sir, Raja sir, the session has just begun, sir. So,
That's only, yeah, just beginning, na, still.
we are just starting, sir.
Ah,
Shall we begin, sir?
Yes, sir.
yes, sir, yes, sir. You can continue, sir. You can continue.
All right. Very welcome to all of you. And today we will be discussing primarily about patents only, the remaining part of patents. And from tomorrow onwards, it will be like other types of IPRs. To brief yesterday's session, as on what we covered within that, includes things like about IP, about IPR rights, and then some of the examples from IP, understanding what all can be protected through IP, different types of IPRs, and along with that, what patent means, and what all can be patentable, what all can be not patentable, some of the examples of patents from different fields. Today, we will be discussing more of like, what are the different types of patents, and what is the process flow in terms of the day on which it is being conceptualized in your mind, and the day it is being filed with the government office. Together with that, what happens in with the government office once you file your application, that is say once a patent is being filed, so filing till the grant of that particular or rejection of that particular application. Apart from this, we'll be discussing some the difference between what is there into published application and granted publication. Together with this, forms with reference to that needs to be filed while submitting your application with the Indian Patent Office. Together with this, few case studies, and then briefing about questions from different from the field of patents only. Something like where can patent be filed, who can file it, if software can be patented or not, and if prototype is required or not. Begin with say what are the different types of patents? First, is like provisional application, which is an application that doesn't comprise of all the
కొంచెం అదే
details.
సబ్జెక్ట్ వేసేవా ఇది అవగంత అవుతాం
Provisional application is something that gives you ability to define what is already being conceptualized in your mind, but you are still working onto it, and probably the end shape of the product is yet not developed, or you are still experimenting onto it, and it needs to be done something more into it to get it through. Under those scenarios, government allows you to file a provisional application, which means that you had to submit a non-provisional application or a follow-on application within a duration of 12 months from the filing of provisional application, providing all sort of details that was required to be provided by you into the application while filing of the provisional one. Non-provisional application is the application that contains all the details of your invention in terms of its applicability and in terms of its enablement, as in how one can actually perform the invention or execute the invention that you have put onto the paper. Together with this, this application does comprise many sections within those, and out of all the sections, a section is called claim, which is of at prime importance, as that defines what is being, what set of IP rights are being given to you for the application that you are submitting with the government office. Then comes the convention or foreign application. Now, this is something which is, say, there's a foreign nation person and he wants to file in India as well. In that particular case, the first filing that he has done into the place where he's living, say in UK or US or any other place in foreign land, under those scenarios, those applications will be termed as convention or foreign application for the application that is being submitted into India as well. The PCT application. PCT application is an application that is being filed with a worldwide international organization, which is there to manage what all is being the IP rights of people filing from different countries and how it could be protected. Together with that, if you choose the PCT application route, under those route, you are being allowed, or you are being given a timeline of roughly more than, roughly around 31 months from the date on which you are filed in your native country or into the PCT. So the date on which you have filed into PCT, together with that, you have got 30 months duration within which you can file in almost any other country without letting any other application harm what you are submitting into your application. There's another term called patent of addition, wherein this comprise of as anything on top of your earlier submission with the government office. So the day you had filed something, probably in a later date, probably within a day or two, or in a duration of 1 or 2 years, or probably within the time span in which the patent is still valid, you are filing an application which is having some incremental modification or a slight modification into its earlier versions. Under those scenarios, you can submit it in the name of patent of addition. With this, what benefit you get is something like your application, the new application will be considered from the same date on which you had filed your earlier application. There is something called, another one is divisional application. And divisional application is something which is being derived from the original application that you are submitting into the patent office and is filed before the grant of that particular application. What comes next is the flow chart in terms of from the day on which you conceptualize an idea until the time it reaches to filing of that particular application with the government office. How it goes into picture as something like, once you thought of something, you put that onto the paper, detailing all sort of components along with its functionings into it, so that any person who reads it should be able to create a prototype out of it, or should be able to do something with it in practical terms. Once that is being drafted, it is required to be examined by some external agent or by you yourself to determine if at all what you are proposing is having something new into it or not, or say testing on your own whether or not it fulfills all sorts of patentability requirements or not, as being determined or put in by the government office. So once being examined by you or say any external agency to whom you had contacted, based on their results or outcomes, what is required is to say, probably you may be interested to rework onto what you are earlier put in onto the paper, so that it is having much more beneficial impact in terms of what it is having in its current state. or else if it's in positive results have come in, then in that particular case, you can put that application for drafting request, wherein again for this as well, you can draft it on your own or take some external agencies' helps. Once it is being drafted, it is required to be filed with the government office from the that government portal medium or through by manual of it. Now, within the government office, the way your application get processed once it's being filed with the government office is something like it takes roughly a duration of 18 months, first 18 months from the date of filing to get published. And once being published, it is required by you to put in a request for examination from the examiner for the application that you had submitted with them. And the duration within which this request could be filed with the government office is something like 48 months from the date on which it was being filed in the Indian Patent Office, or else the date on which it was being first filed in any foreign nation as well.
Did you hear any voices?
Hello?
No? Only my voice?
Yes, I can hear you.
Audible.
Audible? Okay. Can you hear now?
Yes, sir, audible.
Okay.
Sir, audible.
All right.
Yes, sir, it's audible.
Right. So once a request for examination is being submitted, say within the timeline as being defined by the government, that is a Indian government, say that is 48 months from the date on which it was first filed in India, or say any other foreign nation from where it has come into India. Once you had filed for examination, requested for examination, its examination is being conducted by the examiners sitting in the patent office. And once that examination is through and based on their findings, examiner's findings, the first statement of objections are being framed and being shared with you so that you could respond to it in a time frame of say not more than 9 months. 6 months is the normal duration, and there is an extension being provided of 3 months in addition to the 6 months. Together with this, once you replied for the objections that are being raised by the examiner, and if your application now fulfills all the compliance as being required by the patent office, it will either be into grant mode or objections may still come in, and based on that, there could be some decision making, something like whether or not this application should be rejected, or some more objections could be put in, or one should give a grant to this. With all this, there are 2 times wherein anyone from the world can actually raise opposition for the filing that you submitted. The first opposition can be raised once the application is being published and yet not granted within that tenure. So the date is being published, and within a duration of 6 months post that, any oppositions could be raised by anyone from anywhere. So, apart from this, once it is being granted, there is again a possibility of opposing it, and that could be say within a tenure of say 1 year, first 1 year. And once this period is being through, if at all you want to oppose it, then the only way for that will be to challenge it and get it invalidated through some other routes. Now, something about timelines within the patent prosecution. So once your application is being filed as a provisional application, that means that you had to put in ordinary application or non-provisional application within a duration of 12 months from the filing of provisional application. Apart from this, you need to fill in a statement and undertaking regarding foreign applications if at all your application is also having a corresponding member or a similar member that you have filed in any of a foreign nation, or it is coming through foreign nation itself. In that particular cases, one has to provide all those details through the Form 3 along with within a duration of 6 months from the date on which it was first filed in India. Then thereafter, the request for examination, as told earlier, could be used to file, the form that is being used to file for it is Form 18. The time duration for it is 48 months from the date of first being filed into any country. Then there is another form, Form 5, which is being used for filing declaration of inventorship, detailing all the people who had worked onto that particular invention, along with their name, addresses, and other details, which it could easily be confirmed that yes, it belongs to this particular inventor. Now, within this, other details like complete specification, and this requires to be filed with the government office within a duration of 1 month from the date on which you had filed your application. The timeline within which one has to respond to any of the responses that examiner, any of the objections or concerns being raised by the examiner is 6 months, and then an extension of 3 months, so in total 9 months. Now, if you want to go for pre-grant opposition, then the duration is 6 months from the date of publication of that particular application. But it should be before the grant of that particular application. For post-grant, the form is Form 7, and one has to do this within a duration of 1 year once it's been granted. Any of the deposits in terms of biological material that needs to be submitted for the application that you are putting in, the duration is 3 months from the date on which this application is being filed. So the only kind of a type of a prototype that is being required is in terms of microorganisms, wherein the strains of microorganisms are required to be submitted along with the application that you are putting in. Indian government also requires you to provide some information relating to, if at all, it is being worked upon, whether or not you are working onto it, or you had licensed it to someone or not. It is being followed, or it is being used or not. So that is something that needs to be informed to the government, and the duration that is being set for it is once an application is being granted. So post that, after each calendar year, within a duration of first 3 months, one has to do this. So your application, if being filed, say today, so and is being granted, say in year 2021, then in that particular case, from 2022 onwards, you need to provide this. And the timeline is the date, the year when it gets completed, say December 2021 or December 2022. From that particular date till the next 3 months, so that means that you need to submit it the closing of financial year, that is 31st of March of the following year. Now, what sort of papers or proof you get once your application is being published or is being granted by the Patent Office? So what Indian Patent Office does is it publishes journals wherein they put in details about those applications which are being published as well as being granted. And in those publications, the information that is being captured includes something like title, abstract, a bit of a bibliographic details about the invention, and some of the applicant and inventor's name. No other details of that invention is being shared into these journals. It's just a one-pager, and the only thing that is available from the text side is just the abstract part and the title. In the granted application, again, the journals that are being published again comprises of the same thing, wherein abstract along with number of claims that are being proved by the government. Together with this, a certificate of grant is being provided to you along with a letter wherein it provides you info about the grant of that application. Now, components within that particular patent application or the granted application, what are the different headers that are there into it. which are required to be which are must required to be written into it, so that your application could be easily identified. One can read it, make an understanding out of it, and do work upon it or research upon it as per his need. The particulars that are there into your disclosure or your invention disclosure that is being submitted with the government office includes information like title of the invention that you have created, abstract, which is not more than around say 150 words or so, period of the invention, roughly 2 or 3 lines, providing info about some sort of detailing in terms of what it relates to, what you are about to explain in this particular disclosure. Background in terms of what sort of problem you're trying to solve through your inventions. Summary will comprise of a brief info about the way your invention is being carried out. Detailed description will have a complete elaboration along with figures and all, figures enablement and all, that how each and every component are related to each other and what sort of messages are being transmitted from one particular component to another, and the way they are communicating with each other or signaling to each other is something that is being put into detailed over here. At last, there will be claims and drawings as well. Drawings will be in line with what you created, and claims will be something that defines the rights for which you are being given protection for. This is something which is of a nature that must be written with the help of an expert in the field, so that your application may not be discarded for unknown reasons or for any of compliance issues or some other reasons raised by the examiner. So abstract having something like 4 or 5 lines, and then claims it could be much more detailed together with a complete specification, which is not being shown in detail over here. Now, there are roughly around 30 different forms that are required for filing of a patent application in and say during its prosecution as per the need. And within these, there are a few of the forms which are being required to be filed at the time of filing of the application are being put in here, so that you know what it looks like and what to do with these forms. So this is the form 1 snapshot, and in this it requires you to fill in details like name, address, along with if at all it is being published or filed anywhere else as well. So those informations along with any sort of declarations that is important for those applications. The amount of fees that it requires is something around 1,600 to 8,800, and this variation is for the reason because of the different fees being entitled for different entities. Say if you are a college, different fees applicable to you. If you are a sole inventor, then a different fees is applicable to you. If you're a small company or a big company or a student or a startup, so based on that, fees are being segregated, and that's the reason for this range. Then there's another form called Form 2, and it is being named as Provisional Complete Specification. So this form is required to be submitted along with the complete specification, detailed specification that you are putting with your application. So it requires information about the applicant's name, address, nationality, if at all that application was being submitted, along with the provisional application or not. So those details, along with that, some informations like it requires something like say fees as well, and that fees depends on the amount of number of papers that are there into it, together with the number of claims that you have written into it. So for the base fee is being kept as 0, and this includes a bunch of 30 papers which can have 10 number of claims. If at all you increase even a single claim beyond that, you need to shell out a bit
anything more?
extra money for that.
Message me. Message karo.
Then thereafter, say there is a form 3. What it says is any statement or undertaking under section 8. So it asks about informations like if at all you had filed your application into any other country, if rights for this application is being owned just by you or some other person as well. And together with this form doesn't require any fees, and it is just for keeping the patent office knowing what is happening for this particular application, a similar application that is being filed into anywhere else in foreign nation. So what is happening with its prosecution that needs to be updated over here with the help of this particular form. Then there is Form 5 that asks for the number of inventors that are there, along with declaration from each of the inventors to put in their signatures as well to confirm that yes, all these were the inventors who worked onto it. And this particular form doesn't require any fees together with that. Then there is Form 9, which is request for publication. And if at all you want to request for, say, earlier publication of your filings, in that particular case, you can just fill in this form and submit it. And this does entitle for some fees as well, which ranges from around 2,500 to 13,750 rupees. And say, if at all you don't file it, the publication will come only with the normal course, that is, say, 18 months post its filing date. Now, something from, say, on a startup from India called NanoClean Global Private Limited, which came into news when a lot more pollution was there during the time of the Diwali season, Diwali fest. And what this was comprising was a small nasal filter that could be taped onto your nose opening so that any air that you breathe in could be filtered before reaching to your lungs. And the price of it wasn't too high, and you don't see any other company selling anything in line with this, just for this reason that this company was able to secure a patent for this, thereby barring other companies to enter into this segment or brought in exactly similar products. Though it was being recognized by many countries, many governments, along with the then president of India, Pranab Mukherjee, and they have been able to sell it into more than 30 countries by now. And the only reason for it not being copied by someone else is because they have got their IP secured within time in India as well as in other countries. Now, an example of India's first electric motorcycle, which was being sold into the market in the name of RB400 by Revolt, though it was being conceptualized much earlier by another company named Blacksmith Electric in the year 2004. From 2004 onwards, that Blacksmith Electric keep on modifying their versions and is still into that particular gear wherein they are modifying their bikes to let it come into the market. And there have been 3 versions so far by them, one in the year 2004, another is in 2014, and third is into 2019. In the year 2019, another company in the name of RB400 did start selling their electric bikes. And within this particular bike, there was a number of features that was meant to be patented by one or the other fellow. Some of the features that it included were patentable features, were like fully digital instrument clusters, remote key control, along with an option for locating your bike with the help of that particular remote itself, together with that real-time bike diagnostics and getting it conveyed into the connected mobile phone, and has got adjustable foot packs, but still no other vehicle is available that allows someone to adjust the foot pack. Together with this, it was having a voice-enabled start so that you can give a voice command to get this vehicle started. The Blacksmith was a company that did got secured some of the patents onto things like swappable batteries, which is, say, once the battery is being exhausted or drained out, you can just remove those batteries and put in a new battery so that you can just rerun your vehicle again without requiring you to waste some time in charging of your batteries. There was an indicator, U-turn indicator, which could be auto on because of the artificial intelligence being equipped within that particular vehicle. It was also equipped with a reverse gear mechanism so that this bike could easily be put into reverse gear mode and be driven as per the need. Now some case studies from, say, this is the example of a company called Aero Products, and they had got a patent, which is a 5 series in the US, and that patent was relating to an inflatable bag that could be sealed all across its periphery, and a valve was being provided so that this valve could be used for inflating that bag. Sealing all around its periphery and having a valve was something that was being protected through this particular patent. And they were also selling this product into the market. Another company in the name of Intex Recreation once saw that this particular product was having a high demand. They themselves created it and was selling it into the market. Once Aero Product came to know about it, they asked to Intex to negotiate for its licensing, but they weren't ready to do so. And for those reasons, then Aero Products moved to the court, and it was being decided into the court that Intex should pay a damage of roughly $2.95 million for what they had copied into their product. Further, this amount was also doubled by the court as it was being proven into the court that Intex did it intentionally, and there wasn't something that Intex wasn't knowing about it. They were knowing about it and did that intentionally to increase the market share of their goods being sold into the market. There's another case study wherein Pfizer, Teva, and Sun Pharma were all selling a similar salt-based medicine into the market. Pfizer was the company who was actually owning patent rights for that particular drug named Protronics. And this patent was about to expire in the year 2011, but Teva and Sun Pharma didn't wait it for this patent to expire before launching of their products, their salts, similar salts-based medicines into the market. Teva launched their generic copies in the year 2007, and Sun Pharma did the same in the year 2008. When being proven into the court that Teva and Sun Pharma did actually copy the salt, the IP rights of Pfizer, then it was being asked by the judge to pay roughly
Hello.
$6 billion
$6
million to Teva, to Pfizer by Teva, and $550 million to Pfizer by Sun Pharma. There was another case between Peloton versus Flywheel Sports, where Peloton was owning a patent which relates to stationary bikes and also classes based on what the person exercising is asking for. Flywheel did made a similar product and was selling into the market. A few years court cases were going on, but at the end it was being decided by both of them. Settle it out of court, and it was being decided between these two that Flywheel won't be selling anymore.
Sir, there is a noise on background. Please mute all the participants, please, sir.
Okay.
Muted also, Sandesh sir, you can continue.
Okay, thanks. Another case is of Polaroid versus Kodak, wherein Polaroid was a company that was owning patent in the field of instant photography, and Kodak was a company who was infringing onto Polaroid patents into their products, copying of their technologies into their products. And once being proven into the court that Kodak did copy Polaroid patents into their products, it was being ordered to pay around $9 million in damages Polaroid by Kodak. And this amount was further amended to $925 million because Kodak wasn't able to pay this money within the time set by the Yep. Then there was another case wherein between a university named Carnegie Mellon University and Marvel Technology Group, wherein Carnegie Mellon University was owning patent that relates to increasing accuracy of reading data in any through a hard drive circuits. And this particular tech, which was being already protected by Carnegie Mellon University, was copied by Marvel into their products. And once being proven into the code, Marvel was being asked to pay roughly an amount of $750 million to this university. Another case where an Imperium versus Samsung, and in this particular case, Samsung was infringing two of Imperium patents, and these patents were related to reducing flicker that is caused during taking of pictures because of fluorescent lighting. And when being proven into the court, it was being decided that Samsung must pay an amount of roughly $6.9 million to Imperium for copying the IP rights of Imperium. Now, what is it that you can do in order to create an IP within the organization or college or campus or university where you are already working? This is something that has to be done through something like first understanding what sort of problems industries or people are still facing with the products that they are using currently. And based on the identified problems, if you could come up with some solutions for that and see for its acceptance or non-acceptance in terms of whether or not if similar solutions were also proposed earlier by someone else or not. If yes, then of course there's no point of coming up with those solutions, and it requires to think further and coming up with some add-on onto the solutions that you look through. Once you are able to conclude that yes, the solution that you're proposing is new in comparison to what all you know of, it is required to be protected through by one or the other IP rights. And before that, if at all, you could take some assistance to see if it is actually new or not, it's better. And once it's being done, its drafting can be done, and then it could be taken forward for filing with the patent office. Now, what are the fields that you can use for exploring within your domain that you're working upon, as say somehow integrating what you are working with or what you are teaching to your students, as adding somehow artificial intelligence or blockchain or augmented reality, quantum computing or edge computing, things like virtual reality or machine learning along with those, and coming up with some sort of a product or service in line with that, which could somehow solve problems that may relate to something like management of resources or any sort of fraud detections or any investigations, any pre-recommendations or suggestions, any sort of alerts and notifications that could be generated or transmitted to someone, any sort of an autonomous control or complete shut off or sending some communication to someone, some sort of an interactions that could be built around this. So together these two are integrating the field that you're working on or the field that you're teaching with. If you integrate these three together, I hope that some of the solutions may come from your end that may be good enough to be filed as a for securing one or the other patent rights. Now, understanding what all can actually be protected within a product through patent or any other IP right is something like the entire product could be secured, any of the product features could be secured, overall product appearance could be secured, any of the circuit layout that is there into it, any process sequence being uh, put into its manufacturing or its making is also something that can be protected. Apart from that, names that are being used for uh, selling of those particular product and its packaging. Within a service as well, the entire service could be secured and various steps being involved for its execution, any sequence for delivering of those services, the way it appears, the codings that it has, and the name that is being used for selling of those services, any of the content that that particular product or the owner of that particular product is using, or those services is using for selling of those services. Questions like, where can actually a patent be filed? So the first place wherein a patent should be filed will be something wherein you belong to, as in your native country. So if you're living in India and an Indian citizen, the best way to go forward will be to first file an Indian patent office, which is being located into 4 states, something like say Mumbai, Kolkata, Chennai, and New Delhi. And filing of patent application can be done both in online as well as in hard copy. The website that from where you can do so is ipindia.government.in. There's a question as in who can file a patent. So a patent agent or an attorney or a consultant like us or the inventor himself. They all can file a patent by their own. Now, can software be filed as a patent? The straight answer to it is no, but there is definitely a possibility of filing and getting a software secured if at all it is being somehow configured along with a hardware device and is being put in a manner that the software cannot work all alone and requires a hardware device to function better and execute the functionalities that it was meant for is something that can be protected for, or one can take protections for those through IP rights. Along with that, if at all those software does comprise any specific component within that, which is enabling, say, things like communication of software part with any of a hardware component or a sensor, in those scenarios, the way the two are being configured together is something that can again be secured through filing of a patent. Can any mobile app be filed as a patent? A straight answer is no, but yes, if that app has got multiple features within that, and those features are new and does provide some sort of applicability or enhancements in those scenarios, those applications can definitely be secured, not the entire application, but segments within those applications. Those segments could be something like, say, zooming off a picture, which we are seeing through an app by tapping 2 fingers on it, decreasing the size of the image that is there into it by just putting 1 finger touch onto it. Or it could be something like adding some text on top of the picture onto, say, probably images that are being shared with WhatsApp or so. Things like these can be secured through filing of a patent application, even though they are all sort of. So within the app, there are just small elements or small features within those. So those features can be secured. Now, do we require any prototype for filing of patents? the straight answer is no to this, but yes, for biological things or for developing new microorganisms strains, you do require to submit those strains with the authorities so that they do have, you do get a reference number for it, and those reference numbers are required to be inserted along with the application that you are submitting with the government office. Now, some of the databases that are there for freely available that you can use for searching of patents. These are like Indian Patent Office search, which is being termed as ipindiaservices.government.in, public search. There is another that is of Google Patents. There is Free Patents Online, USPTO Patent Search, eSpaceNet based patent search, and a WIPO based patent search in the name of Patent Scope. There are many paid databases as well. To name a few, it is like Questel, PatSteer, PatSnap. You can use it on your own as well, or you can just get it used by any of the consultants from whom you are taking services. That's all from my side. I hope by this time you must be having many questions in your mind. So apart from the questions that I had just put in, if there are any other questions in your mind, you can definitely ask for it. You can all unmute yourself, and or say the person who wants to ask can unmute themselves and then may ask their queries.
Good afternoon, sir.
Hello.
Hello.
Yes.
Yes, sir. One query is there. What is the difference between filing a patent and granting a patent? और अगर हमारा patent file ही हुआ है, grant नहीं हुआ, क्या उसका कोई benefit माना जाता है या नहीं?
Actually, no. Okay, file means it's something like filing of an application means that you had submitted what you had identified as an invention. So anyone can file anything. Okay, you can just file a replica of any other known filings as well. And when say post its minimum time frame, 18 months or so, it is being published. Now, publication also doesn't hold any value until and unless it is being given a grant for that particular application. The only value that you can attain through publication of your filing is something like that. No other person in the world will be able to secure a patent onto what you had first filed with the government.
Sir,
So
please repeat the last line. No one in the world.
Only benefit you will get out of it is say by the publication of the invention that you had submitted. No other person in the world will be able to secure an IP right on what you had submitted with the government office.
Okay, sir.
So there won't be any direct benefit. It is just indirect benefit, and it's not a benefit to you, but say it's harmful for others in a manner that no one will be able to secure a patent onto what you had disclosed.
Sir, जैसे अगर हम लोग जैसे किसी भी जॉब के लिए अप्लाई करते हैं, सो वहाँ पे हमारे पास ना 2 कॉलम्स होते हैं, पेटेंट फाइल्ड एंड पेटेंट ग्रांटेड. तो फिर हम अगर हम फाइलिंग लिखते हैं और अगर हमारे ग्रांट नहीं है तो उसका तो कोई फिर बेनिफिट नहीं होता ना सर, ओनली फाइलिंग ही है तो.
देखिए, जब तक the thing is until unless you file for it, you won't get a grant, right?
Yes, sir. And
to make it actually reachable to grant possession, you probably need to have some expert services. Say your invention may be having some good things into it, but for the reason it wasn't articulated well in line with what the way government wants. For those reasons, it was being rejected. So to avoid those reasons, it's better to take some expert services and then file for them. And to answer further that, whether or not it benefits or not, it may benefit you personally, as companies may still be asking for a number of applications being filed or grant or published. But in practical scenarios, it doesn't do much of a good to a person. But any technology that you see around, incremental version of its earlier known version. So one has to keep on doing this exercise and your filings may be beneficial to someone else who is working on a similar technology and may be able to come up with something much better than what you had proposed. So it will be in some way helping others in other ways as well. So for those reasons, it is helpful. But yes, you cannot gain any monetary benefit out of it if it is restricted to till say only publication and not till grant.
सर एक रिक्वेस्ट है प्लीज आप अपनी पीपीटीज शेयर कर दो ऑर्गेनाइजर्स के साथ ताकि हमें मिल जाए इट्स वेरी useful PPTs for us.
Sure, we can do so, and you can just in the chat box, if you can just put in your name along with your email ID or so, one can definitely, we will be sharing that with you.
Good evening, sir.
Good evening.
I'm Dr. Kavita, sir, from SRM University, Delhi NCR, Sonipat.
All right.
Sir, actually, I belong to management background.
Right.
So could you give some idea related to the contemporary areas which are related to HR and organizational behavior, where we can search for the patents and this kind of thing?
See, within the organization behavior, you may be requiring to know, say, if at all someone is involved into an activity which is harmful for the company, you should be able to know about it. So those things could be enabled through investigating or putting in money onto the resources which can track what an employee and the way he is executing work into his work environment. There are multiple patents into this field which does track any person day-to-day activities within the organization as well as outside the organization, so that you know what all is happening surrounding that person. And based on that, proper alerts could be generated and be shared with the person in the management who is involved into taking decisions for raising alarms or restricting some of the facilities that are being available to that person.
Okay, sir.
All right.
Thank you so much.
There are many other examples along with that, but it is just one of those, right?
Yes, sir. I got the idea.
Okay.
And I also request for the PPT, sir.
You can just put in over the chat box your email ID and your request message along with it that you do want to a copy of it.
Thank
And
you.
all those who do wish to have a PPT of it, you can just put in your request over there and it will be shared to you.
Hello.
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 Hi, ma'am. Yes.
Hello. Myself is Inderbir. I'm a faculty from Punjab, actually.
Okay.
Yeah. Thank you for this wonderful session. It is really very informative. Today's lecture is too good. But I'm not yet cleared with what about the softwares. I know it's copyright. We can copyright our software, but what about, can we go for the patents also?
You can go for the patents, but within patents there are specific requirements, right? Which is something like it has to have some unique features within that, and those unique features should be listed out from the entire software codings. Say, if you could just elaborate through your software, post writing of your software, that what is the kind of outputs you want to avail through it, what sort of user controls you are trying to give through this particular software. So if you could just put that onto papers and share it with people like us or any other consultant, they can definitely help you out to estimate or make you know what all is there that can actually be secured through filing of a patent.
Oh, okay.
There's not any crystal clear answer. Say for example, OTP, right? One-time password that is being used for any of the financial transactions. You may understand that this is a software component thing. It is being generated through software only. There's no any hardware mechanisms being involved into it. But things like this can be secured through filing of a patent.
Okay. Okay, sir.
All right.
Thank you. Thank you, sir.
If there is any specific requirement, you can just share your details, your queries, along with the inventions that you, or the software details that you want to put in through the patent route, through our business development executive or our coordinator, Mr. Param, and thereafter he can help you out with those.
Okay, sir. Please share your email IDs or a contact number on which I can contact you personally, if you allow.
You can definitely do so. I mean, in the chat box, you can see all such details, right?
Fine. Okay, thank you.
You can see the details over the chat box for this. Yeah. Any other query? Any other query?
1.55.
Hello.
Hello.
Sandesh sir?
Yes.
Jasprit this side.
Hi, Jasprit.
So there were some questions during the lecture. So can I start with that?
Yes, you can start with that, as no one else is asking as of now, so we can take those.
So first question is from Nitika Chauhan. She is asking that does patent once filed can be renewed or not?
They can be renewed once. They can be renewed after the duration from when its maintenance is due. Something like, say, when a patent is being granted, for the first 2 years, you did not have to pay any fees, and they are into active mode. And once it is paying, 2 years are being passed, you had to renew it every year till the time it is being expired. And expiry of that particular patent happens post the duration of 20 years from the date on which it was first filed in any particular office, in any foreign nation or anywhere else. So 20 years from that period, this application, this patent can remain active, and you can renew it till the time you are paying.
Okay, so second question is, do we have to provide any prototype of our work for a patent application?
No, you don't need to provide any prototype. This only in biological processes one needs to do so for microorganism strains. Apart from that, no other prototype like things are being required for filing a patent.
Okay. Another question is that if we are going for filing for invention, for our invention, and someone tries to hack it, or to copy it, so what we can do?
What we can do for that?
Yeah.
Okay. So if at all say you find that someone is copying what you have taken protection on, in that particular case, you can reach to that person directly and let him know that what you are using into your product or services is something which I have already got a protection from government office, and you shouldn't do so. And if you still want to copy it into your products or services, you should take legitimate permissions from me, and if you're ready to do so, good enough. And if not, I would have no other way except to take you to the court.
Okay. Another question is where we can check our required invention, the invention that we are filing for. Where we can check it.
You can look for those through. Okay, you want to search for any of the patents that are already there.
Yeah,
okay.
Yeah, exactly. Someone is asking.
Okay. It is something that you need. You can search onto any of the paid or free databases. Almost in the last slides, I mentioned few of the databases like Google Patents, Patent Scope, or Indian Patent Search, and there is USPTO Patent Search or eSpaceNet Patent Search. These are some of the freely available patent databases wherein you can just put in your keywords and see the documents that are coming through and scroll them to understand what all is being published into what you are filing as an invention.
Okay. Sir, there was a query from in the B code regarding software patent. So can I answer it?
Yes, you can answer it.
Okay. In the B, there is a section in Indian patent law that section 3K, which states that any mathematical or business method or computer program can't be patented in Indian patent law unless it's having any technical specification. So what do you mean by technical specification? Technical specification, I give you example of Ola, Uber, Swiggy services, Zomato services. They are using app-based, software-based tools. But apart from that, they are using some technical specification also. That GPS module is there, payment module is there, some proximity sensors they are also using. So any software patent having some technical specification can be patented.
कभी बंद कर रहा है कभी खोल रहा है नहीं ये बंदा
Hello.
Yes.
So to have a patent, to file, you can file for any specific any invention, but for a software patent, you need to have a technical specifications in your invention. Any questions from anyone else?
Any other queries from someone?
All right, sir. Let's close today's session. Thank you very much, Sandesh sir, for the today's session, and thank you, Jasprit sir, for helping with the doubts in the chat. We will be reconvening tomorrow for a more in-depth conversation on the other IPs possible, as all software cannot be just protected through patents. There are other IPs as well. So thank you very much for attending today's session. And now I'd like to pass it over to Raja sir. Raja sir.
Sir,
Raja.
tell me, sir. Tell me, sir.
Yes, sir. We are closing today's session. Would you like to say a few words?
Hello, sir.
Yes,
Once
sir.
again, I would like to say thanks to all the participants. They are maintaining very good time to run the session very nicely. And our resource person Sandesh Agrawal ji,
Yes, sir.
each and every word and sentence and how to file the patent, what type of patents we can file, everything explained very nicely. Thank you, Sandesh Agrawal ji. Thank you so much.
Very thanks to all of you.
Our participants are there. Principals are there in this in our group, and HODs are there. So many senior faculty members are there here. They all are understanding easily.
All right.
What you are definitely we will file patents, sir. End of the session. We have hope on that. Okay.
Please to hear that, sir.
Towards that. Please prepare us. Thank you, sir. Thank you. Thank you so much.
Thank you.
Thank
Thanks
you
to
all.
all of
Thank
you for
you,
your
sir.
nice timings.
Thank you. Thank you. I'm closing today's
Thanks, sir.
session. Thank you very much for everybody for attending. We will reconvene tomorrow at 4 o'clock or 3:30 when the meeting starts.
Thank you, sir. Thank you.
All right. Thanks. Goodbye.
All right.